Hi there, I'm Paul Omar and I am in Kuala Lumpur, Malaysia. I am here as a consultant to the World Bank and we are engaged with local clients in assessing the insolvency framework. Now, Malaysia is a common law country and its insolvency laws should not be unfamiliar to anyone who has ever looked at the British Companies Act or indeed the Insolvency Act. In Malaysia, there are a few procedures that serve to assist debtors. In the Companies Act of 65, which is based on the British model from 1948, you have schemes of arrangement, which essentially is a court-driven process. So a debtor comes to court and says, I have a proposal to make to my creditors and I hope to do the following: restructuring. Now, the restructuring might well be operational. He is trying to change something with respect to his business. Or it might also be financial. He can't quite pay or meet his payments on his contracts. So what he would like to do is to be given more time, or for his creditors to forgive him some of that debt. Now, schemes of arrangement are not complex. The structure is very simple in the law. But in Malaysia, schemes of arrangement are little used because lawyers charge very huge fees and most debtors can't afford them. What alternatives are there in the current framework? I'm afraid that the only other alternative is liquidation. And liquidation means exactly what it means, liquidation. What you do is you gather together the assets and you pay them out according to a list of priorities to the creditors, and if anything is left, to the members of the company. Liquidation ends the business and can be initiated by both creditors and by the members or shareholders of the business. So with schemes of arrangement and liquidation being the only procedures available in Malaysia, what does that tell us? Well, is the environment favorable for debtors? It doesn't look like that at all. Is it favorable for creditors? Yes, it seems to be. Now, the Malaysians are engaged in a program of reform to all aspects of their insolvency law, both corporate, so dealing with companies, as well as personal, dealing with individuals, with small and medium enterprises, and with institutions like partnerships. The company law reforms have already been completed, and they have resulted in the Companies Act of 2016. As of the day we are speaking, it is not yet in force, but it is expected to come into force at the beginning of 2018 in stages. Now, this Companies Act is quite revolutionary because it still keeps schemes of arrangement, it still retains liquidation, but it introduces two new procedures, and those procedures are patterned after procedures that any student of English insolvency law will be familiar with. It contains corporate voluntary arrangements and administration. But administration here is called judicial management, because that is also the term used in Singapore, which is next door. And Singapore adopted judicial management very shortly after the Insolvency Act of 86 was introduced in the United Kingdom. It is that model that Malaysians this year have brought in. Now, what do these two procedures provide? Do they inculcate, do they create what we might know as a rescue culture? Now, both CVAs and administration serve a particular purpose. They enable the debtor, in the case of the CVA, or the debtor or the creditor, in the case of administration, to ask for the court to grant the business a breathing space. But what in essence is happening within this breathing space? That all depends on what the concept of rescue actually means. Once upon a time, rescue meant saving the company that asked for the help of the court. Nowadays, rescue means looking at the business that that company owns. And that business might actually be much more efficient or productive in the hands of another, someone prepared to spend the time and effort that evidently the owners of that business or the people who owned and ran that company could not spare. Now, this type of asset sale or business sale is very, very common in rescue these days and is the norm in practice. What Malaysia has done by introducing corporate voluntary arrangements and administration is to introduce this form of rescue, the business rescue rather than the entity rescue. It doesn't mean, of course, that if you are a company facing difficulties, that you can't go to the court and say, one of these two procedures may be useful for me. Of course, you have to make the business case, because these are expensive procedures, they're not lightly invoked, and they require the appointment of an insolvency practitioner. So you are going to incur costs in your restructuring or in trying to improve the fate of your business. And remember that most businesses in financial difficulties have very few resources available to them. But the environment has certainly improved. So can we say that Malaysia has adopted the rescue culture? Well, unfortunately, not quite. Because one of the procedures I completely forgot to mention that also exists in the Companies Act 1965 is a procedure that the United Kingdom abandoned quite some time ago, and that is called receivership. Now, receivership is only related to insolvency in that it's quite commonly used in the case of insolvent businesses or near insolvent businesses. What receivership gives to the creditor is the right to appoint someone to take over the business, and usually to manage that business with view to improving it or to selling its assets to satisfy the secured creditor, essentially repaying the secured creditor what the secured creditor has lent. Now, when that happens and the assets are taken out of the business may have nothing left, and so it will go into liquidation. But in some cases, the activities of the receiver and manager result in the business being sold to a third party or to an external investor being found who is prepared to put the money in that will serve to repay the secured creditor. Only in those instances can we say receivership will act as a rescue type procedure. Now, receivership survives in the 2016 legislation, and unfortunately the definition of corporate voluntary arrangement says that if you are a company that has granted a charge in favor of a secured creditor, you cannot use this procedure. But you can, of course, apply for judicial management. That is an option still open to you. So in terms of smaller companies and what they might wish to access, the options may still be open. In terms of larger companies, many of which will have borrowed against collateral by giving security to a creditor, the options are a little more limited. So Malaysia does have a partial rescue procedure, and one of the important things to find out when the Act comes into force in 2018 is whether the practitioners and the courts will be able to adapt to what is a sea change in the attitude towards the survivability or viability of companies. That, in essence, is what is happening today in Malaysia.